first, this courtroom scene sounds routine, just another case being called. But within seconds, it becomes clear this is far from ordinary. This is a sentencing hearing in a deeply emotional and controversial case where a life has already been lost, and the only question left is how many years that loss is worth in the eyes of the law.
Mr. Chairman, ready to proceed?
State's ready.
Before the court for sentencing the matter of States versus Sarah Erica on 2503-40, having pleaded guilty to count 1 as amended to aggravated manslaughter in the first degree. So now the appearances of counsel starting with State.
Thank you, Judge Ed Shim, appearing on behalf of the state.
Kate Weigel on behalf of Sarah.
And first I'm going to talk about the pre-sentence report, and then we'll move to the other issues. Ms. Weigel, any corrections, additions, or deletions to the pre-sentence report?
No, Your Honor. My client and I both had the opportunity to review the pre-sentence report. It does appear to be substantially accurate with no additions or corrections.
And anything from the state?
Not with regard to the pre-sentence report, Judge.
All right, very well. All right, again, Ms. Erickson, before the court for sentencing, I'll hear from you first, Ms. Weigel, for the argument, and if Ms. Erickson would like to speak.
Thank you, Judge. Your Honor, I would substantially rely on my letter submitted April 10th, 2026, outlining the mitigating factors that the defense would be seeking. In addition, I did provide to Your Honor and to Mr. Shim this morning certificates of completion that were alluded to in that same letter.
As the defense speaks, they try to humanize the defendant, presenting her past trauma and emotional struggles as mitigating factors. They argue that psychological abuse and manipulation played a role in her actions. But this raises a difficult question. Should personal suffering reduce accountability when a life has been taken?
In addition, Judge, I would ask that Your Honor consider finding mitigating factor 15, whether the defendant is a victim of domestic violence that is subjugated to, in this case, substantial psychological abuse that was a contributing factor to her criminal behavior. My client was residing in a home where she was demeaned, belittled. Any idea, any problem she had was subject to ridicule and being belittled, which I think left her, along with some other factors, to various influences and manipulations that sadly led us here, Judge. So I would ask that Your Honor consider all of those mitigating factors. My client and I have gone over the appeal rights paperwork, and she has signed the same.
All right, thank you. Just for the record, I did review the sentencing memorandum as well as the certificates. Do you want to say anything, Ms. Erickson?
Yeah. First and foremost, I want to apologize from the bottom of my heart to Emily Tammy. I know what happened is heartbreaking. It's something I can't fix and should have never happened. I take full responsibility for my actions while getting high. I wish every day that I could go back and change it. I did and still do love my sister, and I will miss her the rest of my life.
Mr. Shim?
Thank you, Judge. With regard to mitigating factors, we'll get that out of the way. I would ask Your Honor to find mitigating factor 4 not to be applicable. There is no justification in taking another person's life because you may be endangered. With regard to the request for 12,
The prosecution pushes back strongly, rejecting these claims due to lack of solid evidence. They emphasize the defendant's criminal history and the seriousness of the crime, arguing that there are no valid mitigating factors. In court, emotion is not enough. Every claim must be proven, and the stakes here are measured in years behind bars.
providing simply factual information at your plea does not rise to the level of mitigating factor 12. With regard to mitigating factor 13, which was requested, she is not a youthful offender, so I would ask Your Honor to not find that. With regard to mitigating factor 7, she did not maintain a substantial period of being crime-free. In fact, within 3 years of graduating from a drug court, she committed the present offense. With regard to character and attitude, given the history, Judge, and given that she actually graduated from drug court and yet she committed these offenses, I would ask that Your Honor not find that. With regard to 15, the factor still requires some reasonably competent evidence. None has been provided, so I would ask that Your Honor not find 15. I would ask that Your Honor find objectively aggravated factors 3, 6, and 9, the likelihood that she will commit another offense, her extent of her criminal history, and the need to deter her as well as others. With regard to the victim, Judge, I have family members here. I want to acknowledge everybody that is here. First, I want to start with Barbara Merrifield, who is going to speak. Richard Crudas, her uncle, is on Zoom. Jim Crudas is also on Zoom. Patricia Del Corio, who is actually the grandmother of Ms. Erickson's son, will also like to speak. Judge, in order of appearance, it would be Merrifield, then Del Corio, Richard Crudas, and then Jim Crudas. But there's other people in the audience here too I want to acknowledge. Jennifer Merrifield is her cousin. She is there. Alicia McDaniel and friend. Phyllis McKiernan is the fiance of Richard. And Eric Glover is here as a cousin. So I want to acknowledge them and thank you for being here. And I present Barbara Merrifield to speak on behalf of Emily Crudas and family.
Then come the victim impact statements, and the entire tone shifts. Family members describe the pain, betrayal, and devastation caused by the loss. These are not legal arguments. They are raw human emotions, reminding everyone that this is not just a case, but a life taken and a family forever changed.
Good morning, Your Honor. My name is Barbara Merrifield. I'm Emily's one of her aunts. I'm sorry, let me just compose myself.
Just take it.
Your Honor, when I first got the call that Emily was gone, it almost killed me. Okay, I knew right away that Sarah had something to do with it. Okay, her mother had made up a will right before she died and had me in charge of it because she did not want Sarah in charge of it. Okay, I have a video of it. It's not just me saying it because she knew something would happen, Your Honor. Okay, Emily looked up to Sarah. Even everything Sarah had always done to her all her life, Sarah loved her older sister. Emily loved her older sister. She did everything to try and make Sarah love her back, okay? You don't know, Your Honor, what this has done to everybody in our family. It's not just us, but to Sarah's kids too. It has ruined their lives, okay? I don't know if she ever thinks about what she did to her own kids, but it's ruined her kids' lives too. How the heck could you inject your sister with fentanyl, knowing the stuff that kills people? How could you do that to your little sister, Sarah? It wasn't bad enough when you tied her up for days, and I got a phone call while I was out of town in the middle of the night telling me that she had been tied up for days. I had her call the police. I thought that was bad enough. And now, right after that, she gets killed. If I would have gotten my way, Your Honor, I would never, ever let this woman released from jail. Okay, because that still wouldn't be enough time for what has been done to Emily. Okay, in my eyes, it was premeditated and greed. How could she disrupt so many lives? Okay, Emily was such a beautiful, beautiful little girl, so happy. Everybody just loved her. All this were financial needs. They had everything they could use and have. They inherited a house, money, everything. But Sarah made sure she got rid of Emily so she could have all that. Okay, so I just want to put that out there, Your Honor. And just one more thing, and I'm not just saying that about Emily. I was an awesome aunt to Sarah. I have always been there for Sarah since the day my brother met her mother, for Sarah and her children. So I'm not trying to be, anything here. Sarah knows how much I loved her and what I did for her. But right now, I just want justice for Emily. Thank you.
Able to get Patricia Del Corio. Can you hear us, ma'am?
You just have to unmute, Patricia.
I'd like to make a statement.
Yeah, I can hear you.
I witnessed Sarah behavior for a long time. I lived with her for a while, taking care of her ailing mother, who is dying of cancer. I witnessed her abuse. I was a victim of it as well. She was abusive to Emily and her mother. They were definitely afraid of her. Her mother was manipulated into changing her will and I had to be a witness to it. I asked her mother if she was sure she wanted to make those changes. And the mother was so upset and intimidated that she just agreed because her fear of Sarah harming her in some way and didn't have the strength to argue about it. Sarah's children have been through so much and witnessed so much turmoil that they need much normalcy, impossible without her influence. I feel they are better now that she is no longer involved in their lives. I am praying that the law will work as it should and sentence her to the longest possible punishment because she is a danger to society. Her actions were cold, cruel, and premeditated, and she should not be allowed to be anywhere but behind bars.
Thank you.
You're welcome.
Richard, are you ready? Okay. Oh, I thought you.
No, that's the grandfather.
They have the same name.
Okay. Sit, stand, or feel comfortable stand.
Whatever makes you.
My name is Rich Crutch Jr., uncle to Emily and brother to her father, Jim. I wish I had made it to Joe Reagan's sentencing hearing, however, I did not. Sadly, he also got a sweetheart plea deal like the one here today. First, I would like to say thank you to the New Jersey State Police for pursuing this case for over a year, and ultimately, their hard and dedicated work got them the evidence to make arrests. Next, I would like to say how sick and disappointed I am in the deal that was given to Sarah. Emily was just 21 years old and murdered premeditatedly. Emily's murder, orchestrated by Sarah, her own sister, again, despite the language of this deal, was indeed premeditated. Sarah and Joe dosed Emily with Xanax to make it easy to incapacitate her. Then they purposely shot Emily up with narcotics to kill her. The lawyers in the courtroom can tell Sarah to say she was not sure Emily would die, but no one really believes that injecting double-digit bags of heroin and fentanyl into someone would not kill them. Emily, in her last moments, knew she was going to die, and also knew she was going to die at the hands of her own sister and her own fiance. With zero remorse, they went back to partying after watching Emily struggle to breathe and then finally take her last breath. The guilty continued to party for hours as Emily's body got cold, but never as cold as their hearts and their soulless bodies. 8 years for cold-blooded premeditated murder, 8 years for a cold-blooded premeditated murder is a travesty of justice. And I have wrote asking you to increase it, but apparently you cannot. Please do not lower it. Thank you.
Thank you, Judge. I will turn to Mr. Cruz.
We have two. We're talking to James. James, you just have to unmute, okay?
Hello, can you hear me?
We can hear you. Thank you, sir.
On 2/17/23, I received a call, knew her at once, that my daughter was dead. I could feel my heart break. The pain was so intense I could not speak. It was like the world was at a standstill. If I had to describe what it feels like to be paralyzed, this would definitely be it. The pain was so deep, all I could do was stare and beg God to wake me up from this nightmare. My daughter was taken from me through a senseless act of violence, a cowardly act. Although the defendant took my daughter away from me physically, she doesn't have the power to take away the love and memories that I hold dearly in my heart. My daughter was everything, and you took that away from me. My life will never be the same. The pain has impacted me mentally, physically, and emotionally. In a way, some might think we should carry hatred in our heart, but instead I carry pity. Pity for you, Sarah. I beg the courts to reject this plea deal and sentence her to the maximum sentence under the law if that can be done. This was premeditated. She had it planned out and acted on it. And what they did to my daughter, making her suffer for 7 hours, she don't even deserve 8 years. She don't deserve life in prison. But Your Honor, for Emily, if you can reject this and make it more years to the maximum of 20, please do that, please. Thank you.
Anything further, Mr. Schiff?
Yes, Judge. The family in this case, understandable. This is a family tragedy played out in a public forum. The killing of a sibling, a story as old as time. What I have done through my office is at least guide them through the process. Satisfaction, justice, they're relative terms in the eyes of the beholder. Facts sometimes dictate resolutions. I respect the family's opinion. I understand it. I don't know that I would feel any different. This case was resolved, so there is finality in terms of this aspect of the case. I would ask that Your Honor sentence her to the 8 years that's agreed upon. I don't think any lower is appropriate. Thank you.
All right, ma'am, you can please stand up. Defendant is 37 years old, is divorced, has twin daughters, ages 7 up, and they are in custody with their father. Defendant has one son, also age 17, from a prior relationship, and is in custody of his paternal uncle. Defendant received her GED. At the time of the plea, defendant, who was a half-sister of the victim, EC, admitted to injecting her with a lethal dose of fentanyl. This sentence decision is based in part upon information contained in the sentence investigation report or information contained in the court record. Court finds aggravating factor for which defendant will commit other crimes for the following reasons. Ms. Erickson was a recovery court participant from 2017 to 2020. There was one arrest listed in 2009 in Atlantic County for which she was sentenced to 2 years of probation. According to her rap sheet, she was arrested in Florida for possession of CDS. This defendant reported she spent 7 months in the county jail. However, the disposition is unknown. This history convinces the court that the defendant is likely to recidivate. The court weighs aggravating factor 3 as substantial. Aggravating factor 6 is present due to the seriousness and extent of the prior convictions as enumerated. The court gives this substantial weight. Based upon the same evidence discussed previously, the court finds aggravating factor 9 as to both general and specific deterrence, gives it substantial weight. The court finds no mitigating factors here. The court finds that balancing factors, which is not just a number, but also their quality and nature. The aggravating factors clearly and substantially outweigh the absence of mitigating factors. This was a negotiated plea between the state defendant, thus it's afforded a presumption of reasonableness. And as Mr. Schiff indicated, one thing that the court does not know is how strong the state's case was, and that is taken into account in coming up with the ultimate plea recommendation. And I can tell you that however strong you think the case may be, folks, these are terribly difficult cases for the state to prove. So the court finds a sentencing recommendation contained in the plea agreement as appropriate, and it will be followed. The court has heard from the following people. I've heard from Barbara Merrifield. I've heard from Patricia Del Corio, Richard Prudis, and Jim Prudis. Thank you, all of you, for having the courage to get before this court today and say your piece. I know that could not have been an easy task for any of you. Today is a solemn and a difficult day. We're here not only to impose a sentence, but to recognize the profound loss suffered by you family members. And no words from me will ever restore what has been taken from you. The absence you carry is immeasurable, and the pain of that loss is something the court fully acknowledges. To the family, your loved one's life mattered. She was more than a name in a case file. She was a person with hopes, relationships, and a future that were unjustly taken. The grief that you all endure is real and lasting, and the court recognizes the strength that it has taken for all of you to be present here today, in person or otherwise. Sentencing is guided by the law, and it's also guided by principles of justice, accountability, and the protection of our community. The sentence imposed today reflects the seriousness of the harm caused, and the need to hold the defendant accountable and responsible for her actions. It's not a measure of the value of the life lost, because that value is beyond measure. While the court's decision can't bring healing in full, it's my hope that it provides some measure of finality and acknowledgement, that your loss has been seen, your voices have been heard, and that justice as defined by the law has been carried out. The memory of your loved one endures beyond the courtroom. Nothing about today diminishes that. The court extends its deepest condolences to you and hopes that in time you may find some measure of peace. Accordingly, the court shall sentence the defendant as follows as count 1 as amended. 8 years in New Jersey State Prison, subject to no early release act. You must serve 85% minimum, which is approximately 6 years and 10 months before you're eligible for parole, with a 5-year term of parole supervision following release. Jail credit of 445 days, BCCA 50, SSCP 75, LGF 30. Defendant provided DNA sample, court will dismiss the remaining counts. Ma'am, you have 45 days from today to appeal your conviction and sentence. If you can't work with counsel, public defender's office will represent you. If you miss the deadline, you can ask for extension if you show good cause. If you miss the extended deadline, you may lose your right to appeal. You have 5 years from today to make an application for post-conviction relief unless there is an exception. Do you understand those appellate rights, ma'am?
Yes, sir.
And you signed the appellate rights form? Yes, sir. The court is satisfied based upon you've indicated that you knowingly and intelligently executed the notice of appeal rights in time to file a petition for post-conviction relief. You clearly understand your appellate rights. Good luck to you, ma'am. Thank you, folks, for coming to court here to address this court. We appreciate it.
Thank you for accommodating us, Judge.
And you're all excused at this time.
In the end, the judge delivers the sentence based on the plea agreement. 8 years in prison with strict conditions. Despite the emotional pleas for harsher punishment, the court explains that legal limitations and evidence shape the outcome. Justice, as defined by law, has been served, but whether it feels like justice is a question that lingers long after the courtroom empties.